On supplementary cost list, item number 1.
Yes. Yes, who's appearing here?
Your Lordship,
You're in this case?
Sir Dr. Mojika, yes. For the
Where's Dr. Muzika?
Lordship, may kindly take up this matter at the end of the board, Lordship.
On daily list, item number 1.
May it please your Lordship. Your Lordship, item 1 to 5 connected matters, Lordship. I just pray for another 2 weeks' time, Lordship, to enable us to file the affidavit on behalf of the state government, Lordship.
Counters have not been filed.
Not yet, Lordship. Except in one matter, I think item number. Which item number?
In this case, I am representing. In this case, I am for respondent number 6, which is for former respondent in this case. I am not filing any affidavit.
Oh, was not necessary. Yes. So, you are appearing for 1 to 4.
1 to 4, Lordship.
And 5 you are appearing for 5. No, 5, okay, we have
Item number 5, only affidavit.
item 5. Respondent 5 is no longer in the fray.
Lordship.
State respondent 1 to 4.
You're paying for whom? You're paying for?
State your I have already filed on behalf of state respondent.
But you're,
Lordship, items number 1, 2, 3, 4, and 5 are all connected matters, Lordship. So, Lordship, 1 to 4, we are yet to file the affidavit in opposition, Lordship. Only in item number 5, affidavit has been filed, Lordship.
by the state.
Lordship.
And except 6 you're not required to file. You're paying for?
Petitioner.
Petitioner. Can you get item 1 to 4 more? Miss Gisela Leonard, Senior G, appearing for the state respondent 1 to 4, has submitted that the counter affidavit could not be filed today and has sought for some time for the same to be filed. Pray aloud. Item 5. Have you filed a rejoinder as far as item 5 is concerned? Are you filing or
No, Your Lordship.
you're not filing? See, in item 5, counter affidavit have been filed by the state. That is respondent 1 to 4. 6 is not filing any counter. So it's incumbent upon you to file a rejoinder, or if you chooses to do so.
Lordship, I have to talk with my senior, Your Lordship.
Minister, the counsel for the petitioner, Kathok Piper, has sought for time to file a rejoinder to the counter affidavit filed by the respondent 1 to 4 respectively. As prayed for, place this matter out 2 weeks.
Much obliged, Lordship.
Item number 6.
they are supposed to bring something, no?
You are the managing committee.
Lordship will kindly recall that in the earlier occasion, because we have raised the objection that those people who have been appointed, Your Lordship, they are not before Your Lordship. So accordingly, the managing committee, they said we have the we have the people, so we'll bring on record those appointments so that they can,
respond
the
to
petitioner can implement.
My prayer, my writ petition against the order of dismissal, Lordship. I am concerned with my order of dismissal. Now, during the course of the hearing, the private respondent said that some of the person
Yes,
has been appointed. So the court was asked the private respondent to bring on record.
Yes, naturally. Because see, I think we have discussed this last time.
Lordship, yes. Lordship, that's why.
You may have been dismissed illegally, wrongfully, whatever. But if an incumbent has been, has replaced you, then what happened? So you have to take steps to implement.
My lord,
Because let's put it this way: if you are right, then the appointment would be wrong.
yes,
So
this will go.
somebody who has been appointed in your place has to be
Yes,
ousted.
yes.
But you cannot do that without their presence. That would violate the principle of natural justice.
My lord, in fact, suppose Lordship, let them to file. I'll try to satisfy my lord. After that, my lord can.
But
Yes.
it's not necessary. It's not necessary for them to be in the.
Yes, Lordship. Now, Lordship, what will happen? Now, I have seen so many cases passed by this honorable court against the order of termination. In that, none of the incumbents were added as a party, Lordship. Because why, Lordship? Here, suppose if I am here only on the grounds legality or illegality of my order of termination, whether due process was followed or not. Now, suppose in my place, if someone is appointed, now if I succeed, that automatically that will go, Lordship.
Yes, exactly.
That automatically will go.
Exactly. But in the meantime, such a person or such an incumbent would have acquired a third party right.
Immediately he will come for filing a review, Your Lordship.
So you have to clear all this. See, as far as they are concerned, maybe they will have no ground. But we'll have to see. Now, so the fault would be on the authority. Miss Leonard Counsel for the respondent managing. You are for managing committee, no?
Principal come secretary, Lordship.
Or principal come secretary.
Secretary, yes. Because principal himself is the secretary, Lordship.
So I respondent 4 and 5 now. I submitted that the list of the teachers who have been appointed in place of the petitioner who has since been dismissed, whose service has since been terminated, could not yet be filed today, and I sought for some time for the second file. Considering that this is a very long pending matter, however, as for ends of justice, the prayer is allowed. It is made clear that the parties would endeavor to to ensure that this matter is expeditiously disposed of. On premier, this is matter after 1 week. 1 week.
Of last month. 6 to 12, Your Lord. 6 to 12.
Oh, 6 to 12.
Apply, Your Lord.
Item number 13.
Yes.
Pursuant to the last order, I am filing my list of dates along with the synopsis as pursuant to the last order on behalf of respondent 4.
Matter has been heard.
No, Your Lordship, the matter has not been heard.
It was heard, my lord. It was part heard.
From the
Then-
petitioner's side only, Your Lordship.
Yeah. So we have said that it will be proper to submit a list of events, my lord, for the proper adjudication of the matter. So I have prepared my synopsis and the list of events, my lord. But dear my lord, I find out they have sent me one wrong file. I will just point out the letter. Give me the letter. This is the letter. No, the letter. Where you keep it? They have sent me the CEM file, but the EM file is not there, my lord. Here today we can submit the synopsis. I have prepared my lord already, but can it be taken up tomorrow? Tomorrow, my lord, because I have to communicate. Because only that EM file that will be very pertinent, because he will hit me that procedure has not been followed.
Yeah, more often than not.
Yeah,
It's,
yes, my
it's
lord.
always the order of the EM,
EM.
which is challenged, because
More
the
pertinent, my lord.
CM would be the
Appellate, my lord.
appellate authority. So either he agrees or he doesn't agree.
Should have not written. What is this? They have sent me, my lord, the same AKING, but different number. Probably it is the same AKING, but different file number they have sent me. And a CEM file is there, my lord. Record is with me, my lord. But the EM file is missing, my lord, where the entire proceeding take place, my lord.
So
But however, I have prepared my.
I'll give you one week's time.
My lord, 1 week, I'm not surprised because of this condition, my lord. Now, who will come from there? Because day before yesterday also I made a statement, my lord, before the other court that I'll file on the course of the day. They said they are on the way. They have not reached, my lord, till now. They said they have to go back because of the landslide and all. Yeah, because of that, my lord, I don't want to make a statement of 1 week, my lord. I will pray for 2 weeks, my lord, if my friend agree, my lord.
As your lordship, please.
As far as respondent 4, I'm filing it today.
I have already filed mine, Your Honor.
This will be also very interesting case, my lord, where my lord will decide that the NOCMA, if a NOCMA die without an issue and a substituted wife has been given to the male NOCMA, my lord. Now, their kids, my lord, whether they have the right to inherit that AKING or not. That is the core issue, my lord, which my lord will decide.
But
This is my lord.
you see, in Mr. Day,
Yes.
you educate me on this. More often than not, when matter of this kind come before this court, it is only for this court to examine
Yes.
whether due procedure has been followed.
Has been followed or not.
Okay,
Yes, Your
now we
Lordship.
are not to go into the
That
merits.
is the only question that requires determination by this honorable
Because
court, Your
if
Lordship,
I go
under
to the
Article
merits,
56 of the
who
Constitution.
is who, then that would amount to appreciation of evidence
No, my lord.
or leading
Because-
of evidence.
Yes, my lord, here, my lord can also appreciate the evidence to that effect, which is a matter of record, my lord.
Oh, madam.
Matter of record, my lord, can I?
You see, if they conform to the process or procedure,
Yes.
then it's okay.
Yes.
If not,
Then, if Your Lordship may please, Your Lordship, kindly let the matter come up, Your Lordship. We'll make a submissions.
yes, of course, it will come up.
I'm just pointing out. I'm not submitting.
He said that this thing is already done from the petitioner's side.
He said that he has finished, so he don't want me to open the case.
Don't, Lordship. That matter has to be heard again, because this was on the month of March last year. The
Yeah,
matter
I'll hear. you.
My friend is very aggressive, my lord, inside the court, but outside the court, he is very calm, my lord.
That's not true.
Then he should also invite me for a cup of tea.
Definitely, my lord.
Because when we were lawyers, we do that.
Yes,
In
yes.
court, we fight. The next, then after we leave the court, we say, "Come, let's go."
My friend, my lord, we are from the same school. We sit in the same bench. We are from class 4 to class 10. We were together, my lord, in Anthony's school. We sit in the same bench. We spend lots of time together, my lord. But now we have to fight it out.
Those who are in the same school,
Yes,
same
yes.
bench, they tend to fight more than others. On pre-made by the parties, Mr. SD and GC, appearing for the respondent GCDC, has submitted that the records, the relevant record which is supposed to be produced before this court today, would not be done so, and has therefore prayed for 10 in this regard. On the prayer not being objected to, this court would allow the said record to be produced on the next date fixed. This is matter to 2 weeks.
Hello.
Item number 14.
May it please, Your Lordship. Lordship, I pray for some accommodation, Your Lordship, in this matter, Your Lordship. Senior counsel is out of station, Your Lordship.
You see, time and again, this court has requested
My apology, Your
the
Lordship.
parties. If one of the counsel is not here, I'm not particularly saying senior or junior or whatever, but if one of the counsel is not prepared, not able to come, then you should be there. There are a number of counsel appearing for the parties, or the petitioner, or the respondent for the matter. You could do it. If genuine is sought this way, then the matter would not end. It's also 2019 matter. Now we are in 2024. It's a revision petition. Letter counsel for the petitioner has sought for accommodation in this matter on the ground that the learned senior conducting counsel is indisposed. This court, on consideration of the prayer, the same is allowed. It is also, however, it is made clear that the parties should endeavor to ensure that the matter is being taken up and to be heard at the earliest. As paid for, this is matter of 2 weeks.
Item number 15.
Lordship, I am praying for some accommodation in this matter, Lordship.
All the respondents are here?
My lord, this matter has been pending for quite long, and there has been adjournment on this case from the petitioner's side. If Lordship may have the order. And my lord, the only difficulty is that if the petitioners are not willing to argue the matter, they should have mentioned at the very beginning. This has been happening for quite long. Every time the matter is called upon and they say they are not ready. And moreover, the case of petitioner is already not maintainable, my lord. Sir is appearing for the Dorbashno and I appear for the state. So, my lord, it can be today, my lord. I do not have any objections since my friend is quite young also. She does not have much instruction since she is bound by the senior's instruction. I'm praying that this matter can be taken on sharp, my lord, on the next day, my lord. Or otherwise, if at all they are not willing, it should be probably informed to the court, because Lordship also have many other duties with regard to orders and judgments, and even with the councils. So now, my lord, we have to wait every time, my lord. We wait till the end.
See, that is why, you see, the practice is, when the court sits, immediately you should
My lord,
and,
I apologize, Lord.
and make a mention. That is why we have the mention R. But the once again, the petitioner has sought for accommodation in this matter on ground that the general counsel for the petitioner is not prepared to be heard today. Ms. R. Kulni, Leonard J, appearing for the respondents number 1 to 5, has not objected to the prayer, but has also submitted that the matter has been adjourned from time to time on the prayer of the petitioner, which may be noted by this court. Be that as it may, the pre-appeal by the petitioner is hereby allowed. This is matter after 2 weeks.
Thank you, Operation.
Item number 16.
Lordship, I pray that the matter will come up after 3 weeks, Lordship.
This is I think I've made a observation. See, this is matter of
We are yet to receive the copies, Your Lordship, from the court. We haven't received the final complaints, Lordship.
see, copies of what? You have not given them copy.
We have received the order, Your Lordship, with the annexures, Lordship.
They have applied for a new one, Lordship.
You are saying that you have not received.
If we have not received the copies, Lordship, yes, we had. It was the record had been burned in the incident, Your Lordship. I haven't received from the court, Lordship. We are yet to receive, Lordship.
Then you have a copy of the petition.
Yes, Lordship.
You give them. What do you require? Just the copies of the petitioner. Sorry, of the petition. So the petitioner would give you. You could have requested your friend to do it.
Yes, we have applied from the court, Lordship.
Why would you apply? It's not necessary to apply. Had it been the petitioner, in the case of the petitioner, losing the record, then perhaps they may have to apply some annexures or some original papers may have been submitted. So you require only the copy of the petition.
Yes, Lordship.
Yes, then a counsel for the respondent has sought for accommodation on the ground that the brief of the matter has not yet been reconstructed on the original being destroyed by the recent fire, which has destroyed the Shillong Bar Association. Ms. Counsel for the petitioner has submitted that a fresh copy of the petition and all the relevant papers, the petition and the annexes thereto would be supplied to the respondent in course of the day.
Lordship, by tomorrow, Lordship.
In due course. As paid for. That is adjourned for the day. This is the after 2 weeks.
Second call from supplementary cost list. Item number 1.
Yes.
Lordship, if anything, the respondent can start the argument, Lordship.
How can they start? You have to. They have to respond. They are not to start.
Lordship, my colleague has gone to call sir, so he's on his way.
He's
Within the court premises.
How many respondents are here?
5 respondents, my
5
lord.
respondents.
They are all represented. You are representing how many respondents?
I'm 2 respondents, 4 and 5.
4 and 5. Mr. Yogin?
4 and 5.
1 and 2, my lord.
You're for 3. All the respondents are
Represented, my lord. Discharged. Oh.
they are still alive.
I'm sorry, my lord.
Are they still alive?
Yes, yes, yes.
Yes, Your Lordship.
But I taken some, if I recall, of course, I may be wrong also.
My respondent number 1 is in the bed state because due to old age and sickness, he's in Orissa.
Okay.
My lord, may I just draw my lord's attention to order dated 16/5/2019, my lord. Here, my lord.
In this case.
Yes, my lord has already noted what issue to be addressed and what issue to be considered before this court, my lord. Order dated 16/5/2019.
Yes.
And my lord may directly come to paragraph number 9, my lord. Paragraph number 9. My lord has said, now the question is as to whether the learned trial court has appreciated the matter in a right perspective. That is, as to whether satisfaction of the trial court, genuineness and impeccable character of the document has been looked into. This is the only issue, my lord, that needs to be addressed and that needs to be argued, my lord. Now, if I may just submit very quickly, my lord, here. The respondents, my lord, the respondents initially when a charge sheet was filed, some of the documents which were in favor of the respondents, that is the accused persons, my lord, these were not form a part of the charge sheet. Therefore, the client of senior counsel, Madam Pubali, had filed an application before this court. And then this court had allowed to place on records which are in the possession of the respondents also. And thereafter, my lord, we, respondent number 2 and 3 also, the officials of the NEC also, took advantage of the order passed in favor of the respondent number 4 and 5, and we were also allowed. Initially, a charge sheet was the issue or the case was framed. The charges were framed against 1, 2, and 3. Respondent number 1, 2, and 3. And when this matter, when the Madam Pubali's clients filed, then we filed. Then that charge sheet was set aside, and to all this matter was to be reverted back to consider afresh. Documents were filed. At that point of time, my lord, the CBI never raised any objection against the genuineness of the documents, my lord.
The genuineness of the documents supplied by you?
Supplied by us, by the accused persons before the learned.
Which was allowed by the
which
court,
was allowed by my
this
lord.
court.
Yes, by this court, my lord. So that relevant point of time, the impeccable character, the genuineness of the documents which was before the learned special judge was never put into questions. That is the reason why we proceeded to argue the matter. Written submissions and arguments were filed. So which means that at that relevant point of time, the CBI has already considered and admitted the documents that we have submitted before the court was of impeccable characters, my lord. Now, my lord, going by these submissions, my lord, the court did its job, my lord. Section 227, my lord knows very well. It says that documents, what to be seen. If the documents place the records and the documents placed, records and the documents placed before the trial court, and upon hearing of the parties in the matter. In what matter? In the matter of the documents and the records, my lord. And if it finds that there's no sufficient ground, then the trial court shall, it says, shall. The trial court cannot proceed for framing of the charge because the law says he shall discharge and shall record a reason for doing so. So now the question is, they have never raised the impeccable character of the documents. The learned trial court considered, went through the documents submitted by us and the document which was a part of the charge sheet. The court was satisfied that there is no sufficient ground against any of us. That is the reason why the court has discharged all of us, my lord. Now, today, if they come and raise here, because my lord has considered, and my lord has said that this is the only thing to be considered now. So the prosecution has already admitted the documents to be genuine. So my humble submission and my humble understanding is that nothing is left here. Therefore, in this ground itself, the challenge to the discharge application, my lord, filed by the CBI must fail, my lord.
You've already...
My lord, there's a very because it's a very bulky, but I wanted to summarize in a very, very straightforward, my lord, and subject to what they have to submit, my lord.
Right.
That is the issue that is have to be considered, my lord.
We'll hear the petitioner
Yes,
and
my
see
lord.
what he has to say.
My lord.
Well, the contention of my friend that CBI has admitted the document, my lord, it is not for CBI to admit the documents.
Yes.
My lord, this is a case pertaining to a project sponsored by NEC, my lord, to St. Peter's College. A certain amount was sanctioned by about 5 crore rupees something was sanctioned by NEC, my lord, for certain project to be conducted by St. Peter's College, my lord. Now there are allegations of misappropriation and diversion of fund, my lord. So accordingly, CBI came into picture. CBI investigated the matter, submitted a charge sheet, my lord. After CBI submitted a charge sheet, they came before this honorable court that they have certain additional documents which should also be taken into consideration by the trial court at the time of framing of the charge. So liberty was given to them to file those documents before the trial court, my lord. So, my lord, how far that order was correct, like we cannot reopen that, my lord, but this honorable court allowed that. And they placed certain documents, and the trial court relying solely on those documents, my lord, discharge all the accused persons. Now, the contention of my friend that we have admitted the document. My lord, in criminal trial, we are not the one to admit the documents, my lord. Documents are issued by, maybe one letter is issued by NEC to St. Peter's College, my lord. How can CBI admit that document, my lord? The witness will come, whether it is our document or their document, my lord. Those documents have to be proved in court. But the learned trial court simply relied on those documents, my lord, and discharged the accused person. All of them, my lord. I'll just take your lordship to the impugned order, my lord. Though it is little long, my lord, but I think it will be proper that I read the entire order, my lord.
Yes.
Because in trial, my lord, whether these are prosecution document or these are defense documents, my lord, all have to be proved in the course of trial.
Yes.
Well, page 160 is the impugned order, my lord, passed by the learned trial court.
One
160.
Is the order dated?
May 2016. This is the order dated 5th May 2016. 5/5/2016.
May.
Well,
yes.
I'll read from the beginning. This order has arisen out of the consideration of charge in connection with the instant case which was registered as so-and-so on the basis of fact-finding inquiry conducted by CBI on irregularities in implementation of scheme holistic cluster approaches at a grassroots level for sustainable development in NER at St. Peter's College, Shillong, funded by Science and Technology sector of NEC during 2004-2005. That after due investigation of the case, a well-established case against accused number 4, Peter Thoros, number 5, Nancy Dora CM, principal and vice principal of St. Peter's College respectively, and 3 more public servants, namely UN Maji, number 1, the then financial advisor NEC Shillong, Sri R.P. Kharpuri, number 2, the then director science and technology NEC, and Sri A.D. Karshang, number 3, extension officer so-and-so, which are seated under section 120B 420 so-and-so, including section 13 of the PC Act. The Honorable High Court by judgment and order dated 31/12/13 passed in criminal miss case number 17 and 18 of 2013 has directed this court to look into the document annexed to the above mentioned criminal revision petition and the documents produced by the accused number 2, 3, 4 and 5 at the hearing of consideration of charge. Before consideration of charge was taken up, the accused number 2, 3, 4 and 5 have duly produced the documents as well as the documents mentioned in their revision petition. Heard the submission of learned prosecution represented by Special Prosecutor Srimati so-and-so, as well as submission of learned defense counsel pre-open for so-and-so, so-and-so, so-and-so. Let's skip this part. The case of the prosecution on the next page. The case of the prosecution is that the accused Sri Peter Thoros, principal of the above mentioned college, had submitted proposal on the project research-based holistic cluster approaches at grassroots level for sustainable development in NER for financial assistance showing total estimate of rupees 498 lakh, 4 crore 98 lakh rupees directly to the director NEC Sri R.P. Kharpuri, who directed Sri A.D. Karshang, extension officer, to process the same. Sri A.D. Karshang thereafter put the said project proposal with favorable notes and strong recommendation for approval of the same, also supported by Sri R.P. Kharpuri. That the proposal was not accompanied with any forwarding letter from any implementing agency or recommendation from relevant department of the state government and other relevant information such as article of association, bylaws, audited statement of accounts, sources and patterns of income and expenditure, etc. as regards under Rule 149 of the General Financial Rules corresponding to Rule 209 of GFR 2005, that no proper technical scrutiny was done before recommending the proposal, as the instruction at serial number GOI memo number so-and-so dated 8/5/1987, the officials ignored various rules and regulations while recommending to give undue advantage to the implementing agency. The file was thereafter directly handed over to Sri UN Maji, the then financial advisor, who accorded financial concurrence on 21/12/21/215 for the estimated cost of rupees 498.5 lakh with first installment released of rupees 48 lakh without the recommendation of planning advisor NEC, in gross violation of procedure of sanctioning of scheme as highlighted under serial number 2 of the head on procedure for sanction of scheme of the detailed guidelines issued by NEC so-and-so dated 23/6/2000. The financial concurrence was accorded without studying the details of the proposal nor checking the and verifying the correctness of cost of the items violating the conditions under so-and-so, so-and-so, so-and-so. Sri UN Maji put the file to Secretary NEC on 21/2/2005, which marked the same to Planning Advisor on 21/2/2005, who on 24/2/2005 asked for proposal, implementing agency and justification. At this stage, on 28/2/2005, Sri R.P. Kharpuri, Director Science and Technology NEC, placed the proposal forwarded by Srimati C.W. Momin, Joint Director Higher and Technical Education, Government of Meghalaya, by letter number so-and-so. The proposal was initiated on 11/2/2005, but the forwarding from the state government was placed only on 28/2/2005. That Dr. V.T. Darlong, Advisor Forest and Environment, gave his views on the proposal and 10 main action points were suggested for proper implementation of the project, available at page 11 of the charge sheet with his signature on 16/3/2005. The suggestions were agreed upon by R.P. Kharpuri, mention that proposal may be approved subject to the condition highlighted by D. Darlong, Secretary NEC. Also to the suggestion and the further asked opinion of Mr. UN Maji on 18/3/2005. On the same day, that is on 18/3/2005, Mr. UN Maji gave his opinion. Revised proposal was also submitted by Mr. Peter Thoros to Mr. Maji, informing therein that the college has its project management team and does not require another to be constituted, and also certifying that the project does not carry some same objectives as the biodiversity research cell of NEHU, and strangely the said certificate was accepted by the NEC officials. On the said date, Mr. Maji noted that the financial concurrence accorded previously on 21/2/2005 stands good indication that the scheme was approved based on financial breakup indicated in first proposal. On the same day, a proposal was marked to R.P. Kharpuri. However, no record that the revised proposal has been put up in the file is unavailable anywhere in the note sheet, nor the accused official could give any information. The file was thereafter marked to Secretary, who simply gave his approval for estimated cost of rupees 4,98.50 lakh, so and so, with first installment sanction of rupees 47 lakh released to the college. That the activities spoken of earlier took place on the same day, that is on 18/3/2005, giving no scope for compiling revised proposal or scrutinizing it before sanction. There was no formal letter also issued to the college for submission of the revised proposal to incorporate the suggestion of Dr. Darlong, nor was revised proposal put up in the note sheet. The suggestion of Dr. Darlong were also not incorporated in the revised proposal, nor those of Mr. Maji. The revised proposal was never put up to planning advisor for his opinion on the changes, nor was it shown to Dr. Darlong for examination of points raised by him. That it is revealed that the financial concurrence accorded by Mr. Maji on 18/3/2005 was based on first proposal without taking into consideration of some changes made in revised proposal. The changes are available in page 13 of charge sheet in para 7. The write-up of the revised proposal also remained same in almost all aspects except point 3, holistic cluster approach, capacity building, training and IT awareness. That the said changes in revised proposal would have required revisiting the overall financial implication of the proposal, but Sri UN Maji, R.P. Kharpuri and A.D. Kharshang, by abusing their official position and in furtherance to their criminal conspiracy, granted undue advantage to the college. Second installment of rupees 20 lakh was sanctioned on 26/6/2005 on the strength of detailed statement of expenditure and utilization certificate dated 15/6/2005, showing full utilization also on the basis of filed reports, and the same was accorded by UN Maji, financial advisor, who was also in charge secretary at that time. The third installment of rupees 200 lakh was also released instead of rupees 250 lakhs due to shortage of fund after modifying the sanction dated 25/11/2005 towards the scheme from R&D head. It is also revealed that after release of third installment, no monitoring of the scheme for a period of more than 1 year, though several correspondence was done between 27/87 to 24/3/2008 to the college after repatriation of R.P. Kharpuri and taking over by Dr. U.K. Misra. Reply was received only on 27/3/08, forwarding the UC and audited statement of third installment showing disbursement of the entire amount to college for training and higher education, along with further requesting please release of the remaining rupees 231 lakh, so and so. That Dr. U.K. Misra, Director S&T, recommended the same. Mr. H. Vanlal Lutta, V, Financial Advisor, concerned the same but insisted release of the same on receipt of audited expenditure as also suggested by A.D. Kharshang. The then Secretary Sri F. Rajkumar approved the sanction, but Sri F. V. Fanai, DCA RPO, raised strong objection about the full payment due to non-receipt of the audited statement of expenditure and return. The bill and sanction was cancelled by U.K. Misra and no funds were released thereafter. The detailed statement of expenditure shows transfer release of 25 lakh to MEWS, that too from period of 1/6/2004, that is before the scheme, which is not eligible. Further, the fund was not meant for MEWS, nor was there any agreement between college and MEWS or with NEC to make it eligible as per guidelines. That the first installment was shown to be fully utilized, but the account concerned had balance of rupees 4,20,000 and rupees 32 lakh in the FD falling within the period of audit. The further, the transfer of rupees 25 lakhs to MEWS shown to be fully utilized during the period was also false, as the actual transfer was carried out only on 27/7/2005, that is 20 days after audit, and the same is also proved by bank account statement of account number 139946. Thus, the implementing agency submitted false information and cheated NEC, claiming the amount of rupees 47 lakh, that is first installment, is fully utilized, thereby dishonestly inducing release of next installment.
Yes, please.
Simply gave his approval for estimated cost of rupees 498 lakhs, wide number so and so, with first installment sanction of rupees 47 lakh released to the college. Para 10. that the activities spoken of earlier took place on the same day, that is 18/3/2005, giving no scope for compiling revised proposal or scrutinizing it before sanction. There was no formal letter also issued to the college for submission of the revised proposal to incorporate the suggestion of Dr. Dorlong, nor was revised proposal put up in the NS. The suggestion.
My lord, this is
I think
by mistake. This is repetition of the same page, same paragraphs.
So I was wondering why.
Sorry, my lord. Page 167.
Yes, we should go to
167. Para
we should
16.
go to the next page.
Para 16 is at page 167.
Yes.
Para 16. That again, out of the amount released as second installment of rupees 35 lakh was released, transferred to MUS against where also audit was shown before the scheme was sanctioned, which is not eligible since the scheme was not for reimbursement of periods expenditure. That the detailed description of MEWS is available in page 20 of charge sheet. That it is clear from the investigation that the beneficiary has submitted false information for the entire claim, and by producing false utilization certificates, etc., induced release of second and third installment from NEC. That the detail of the transaction of 35 lakh transferred to MEWS is available at page 21. That with regard to submission of utilization certificate of third installment of rupees 200 lakh, investigation reveals that the college had not submitted the detailed itemized statement of expenditure for the said amount even after 2 years, in spite of repeated reminders, which is clear violation of the government norms. That the utilization certificate, receipt and payment accounts mention expenditure only on part payment for building amount to rupees 100 lakhs made to Jimmy Kharkongor, and payment of rupees 103 lakh for land purchase made by P.H. Rinja. That P.H. Rinja confirmed to have received the said amount of the said land sold. However, the purchase of land from Jimmy Kharkongor and payment of rupees 100 lakhs as advance is false and forged by Sri DDCM in collision with Peter Thoros, as also stated by Jimmy Kharkongor, who had denied to have made any such agreement for sale. That as per opinion of GEOD, the sign on the agreement also does not belong to Jimmy Kharkongor. That investigation further revealed that the total amount of rupees 200 lakh was credited by check number so-and-so dated 31/3/2006 in account number so-and-so in the name of St. Peter's College, Shillong on 1/5/2006. A fixed deposit bearing STDR number so-and-so was opened against so-and-so on the same day. The deposit slip was signed by Srimati DDCM for principal, St. Peter's College, Shillong. The STDR was prematurely closed on 27/3/2008 for an amount of rupees 2,21 lakh so-and-so, which is inclusive of interest. This whole amount was transferred on 27/3/2008 to the account number so-and-so in the name of St. Peter's College for training and higher education on the written instruction of Srimati DDCM on the body of special term deposit receipt, with further instruction to reopen another STDR in the name of St. Peter's College Center for Training and Higher Education for an amount of rupees 200 lakh. The instruction was followed by the bank, and on the same day an amount of rupees 200 lakh STDR was opened in the name of St. Peter's College Center for Training and Higher Education, which is still operational. That the above acts is a clear indication that Sri Peter Thoros and Srimati DDCM, both officials of St. Peter's College, Shillong, concerned with the implementation of the scheme, had submitted false documents with the aim of diverting and misutilizing of the government fund allotted for implementation of the scheme, holistic cluster so-and-so. That further the entire expenditure of Peter Thoros through the bills vouchers was scrutinized and compared with the joint inspection conducted, the same reveals as follows. Expenditure to our upgradation of laboratory, out of 38 lakh rupees shown to have been paid to data machine service, Guwahati by the college, an amount of rupees 15 lakh so-and-so was found to be still in the account of the firm. That out of the remaining 22 lakh so-and-so, rupees 11 lakh worth of material equipment were not available during joint inspection in the college. Under village IT empowerment, that under the above mentioned, out of rupees 1,32 lakh so-and-so shown to have paid to Infosystem Guwahati on an amount of rupees 25 lakhs so-and-so still remained unutilized and parked in the account of the firm, and rupees 24 lakhs so-and-so worth of material equipment were not available during joint inspection. That investigation also revealed that the college has submitted false vouchers of items like books, almirah, electrical items, etc. for total amount of rupees 1,06,000 so-and-so. That the college has also submitted vouchers in respect of certain items like purchase of rod for construction of works, repair of motor vehicle, payment of honorarium, etc., which are inadmissible in the scheme for a total amount of rupees 11 lakhs so and so. That again voucher with respect to purchase of vacuum cleaner and refrigerator for a total amount of 31,000 was submitted. However, these were not found during joint inspection. That from scrutiny of these vouchers, a total amount of rupees 1 crore 25 lakh has been found to be misutilized by the college by showing false bills vouchers as follows. The amount released to St. Peter's College, Shillong from scrutiny of the vouchers accepted by NECs, Shillong revealed the following facts. Total amount parked with the firms total is equal to 41 lakh something. Total value of items not found during joint inspection 36 lakh. Total amount where false vouchers have been submitted 1 lakh 6,000. Total amount where eligible items have been charged from the scheme funds 11 lakh something. Ineligible items. Total unutilized amount transferred to MEWS 35 lakh. That the total ABCD, that is rupees 1 crore 25 lakh 7,284 has been misutilized by St. Peter's College Shillong from the submission of bills vouchers alone. That investigation also revealed that the accepted expenditure vouchers submitted by St. Peter's College to CBI through NFC white letter number so and so dated 31/9/2009 amounts to rupees 2 crore 65 lakh only. Therefore, against the amount of 2 crore 67 lakh released by NEC for the scheme, expenditure details for an amount of rupees 1 lakh 2,296 is not available. That the total amount of misutilization of government fund by St. Peter's College Shillong is equal to 125 plus so and so is equal to total 1 crore 26 lakh rupees 9,000 something. Thus, as per the findings of the prosecution is that out of the total amount of rupees 2 crore 67 lakh released by NEC to St. Peter's College Shillong for implementation of the scheme holistic so and so targeted for 5 villages in the state of Assam, Meghalaya and Arunachal Pradesh, an amount of rupees 1 crore 26 lakh has been shown utilized by Sri Peter Thoros and Srimati DDCM being the principal and vice principal of the college respectively by cheating and submitting false documents, false utilization certificates in conspiracy with Sri UN Maji, the then financial advisor, Sri RP Kharpuri, the director NEC, and Sri Eddie Kharsheng, extension officer, NEC Shillong. That it established that UN Maji, the then financial advisor, RP Kharpuri, Eddie Kharsheng, Peter Thoros, and number 5, Srimati DDCM, Vice Principal St. Peter's College, Shillong were involved in offence committed under Section 120B, 420, 467, so and so. Prosecution has relied on the following citation: MP versus Mohanlal Soni, reported in 2006, SCC 338, Hemchand, so and so, so and so. In counter to the charge of the prosecution, Defence Counsel of Sri Richard Patrick Kharpuri and Sri Albert Dondor Kharsheng contended that though at page 9 of the charge sheet, it is alleged that accused number 3, Sri Albert Dondor Kharsheng, made a recommendation for approval of the scheme of accused number 2, Sri Richard Patrick Kharpuri, in total disregard of Rule 149 of General Financial Rules, so and so, on a lump sum calculation without financial breakout. And further, it is alleged that no proper technical scrutiny has been conducted before recommending the proposal, which is in violation of Instruction B of the Government of India memo number so and so. Defense argued that the pertinent question to be looked here is if the aforesaid accused person has the power and the jurisdiction to accord financial sanction to the said proposal. That it is on record at page 9 and 10 that the prosecution admitted that the financial advisor accorded financial concurrence on 21/2/2005 for the estimate cost of project for first installment. The financial advisor, according to the prosecution, accorded the sanction in gross violation of the financial rules. That the charge sheet has alleged that the accused number 2 and 3 made recommendation without going through the content details of the project report. But the pertinent question is whether dereliction of duty is ground of criminal prosecution. That is also on record at paragraph 2 of page 9 of the charge sheet that financial assistance was accorded by the accused person number 1. As such, the implication of the accused number 2 and 3 is not justified and illegal. Defense submits that accused number 2 and accused number 3 has only discharged their duties for processing the proposed project. It is up to the higher authority to scrutinize the project and or to approve and accord sanction, as the financial advisor has to give his own independent opinion on the project. Defense relied on the apex court decision at paragraph 44 so and so that mere violation of rules and where the higher authority is to give their independent judgment and sanction, there is no prima facie case made under section so and so. Defense submits that mere violation of financial rules and government circular in the absence of dishonest intention, the court cannot frame charge by placing a burden for proof on the accused person as held by apex court in so and so. That the prosecution admitted at page 10 that the financial advisor put up the file to the then secretary NEC, who in turn marked the same to the planning advisor for justification. It is admitted by the prosecution that the accused number 2, on receipt of the recommendation of the proposal from the Joint Director Higher and Technical Education, Government of Meghalaya, placed the same before the higher authority. The prosecution at page 11.4 admitted that the planning advisor sought for opinion from one Dr. V.T. Darlong, advisor Forest and Environment, who suggested for inclusion of certain conditions. The prosecution admitted that accused number 2 had submitted his opinion that the proposal of the subject may be approved subject to suggestion given by Dr. V.T. Darlong. The said proposal was considered and approved by the Secretary NEC. That the prosecution admitted at page 12 that in pursuance of the suggestion of Dr. V.T. Darlong, the beneficiary has submitted the revised proposal, and it is on record that the revised proposal was carried out by A1, who submitted the same to the Secretary, and only a copy of the same was marked to the accused number 2 and the accused number 3. That the prosecution at page 14 alleged that the accused number 2 and accused number 3 has abused their official position in spite of their own admission that accused number 1 has submitted the received proposal to the Secretary. That in the instant case, the accused number 2 and accused number 3 have carried out their duty to process and recommend, and the duty and the responsibility to accept and reject is in the hands of higher authority. Being such a case, it is apparent on the face of the charge sheet that the accused number 2 and accused number 3 had no power to grant the sanction. That at page 15 of the charge sheet, point number 10, it is an admission of the prosecution that the accused number 2 has left NEC and returned back to his parent department, and Dr. U.K. Misra took over as the director. It is inconclusive that accused number 2, Sri R.P. Kharpuri, had no more roles to play and has no connection whatsoever with relates to the said scheme. That the charge sheet at page 14 and 15, accused number 3 had only recommended for release of the third installment to financial advisor on the basis of the detailed utilization certificate dated 26/7/2005 issued by Sri Susanta Kumar Roy, Chartered Accountant. The authority to sanction and release the third installment is the financial advisor and the Secretary NEC. The prosecution admitted in the charge sheet that accused number 1, Sri U.N. Machi, who is the financial advisor and the Secretary of NEC. The prosecution admitted in the charge sheet that accused number 1, Sri U.N. Machi, who is the financial advisor and is also holding temporary charge of NEC, accord a sanction to the third installment. The prosecution at page 16 admitted that accused has made a suggestion for payment of the fourth installment, but at the same time insists the submission of expenditure in detail before the actual release of the fourth installment. Interestingly, the prosecution admitted that Sri U.K. Misra, the then director, was satisfied with the utilization certificate submitted by the beneficiary and recommended for release of the fourth installment. That the charge sheet indicates the higher authority has exercised their independent mind and opinion, therefore, where there is nothing to prove that there is a prima facie case against the accused person, and relied on the ruling of the Honorable Apex Court held so and so. That at page 22.19 admitted that accused number 3, in discharge of his duty and function, has brought to the higher authority of the non-receipt of any reply from the implementing agency. Accordingly, put up a draft letter to the financial advisor requesting for detail of expenditure and for refund unspent amount along with its interest. The draft is at Annexure 6 of the document of the accused. The final letter dated 27/5/2008, as corrected by the higher authority, was issued to the implementing agency. That in the absence of motive and absence of any relation of the officer with the beneficiary, the court is to take into consideration all the efforts made by the honest officer before framing a charge under Prevention of Corruption Act, and relied on the decision of the Honorable Apex Court, AIR so and so, that there is nothing to indicate that the accused person number 2 and 3 has obtained any pecuniary benefit for themselves or for their beneficiary, and therefore there is no prima facie case in the instant case. In support of the argument, relied on the decision of the Honorable Apex Court so and so so and so. That the prosecution has admitted in charge that the then director's SNT, Sri U.K. Misra, has made a recommendation and in fact sanctioned the release of the payment to the beneficiary on the basis of the report and utilization certificate submitted by the beneficiary, but surprisingly, he has not made an accused person in the case. Defense contended
What is
that
the sum and substance of this order?
Well, these are the submissions of accused number 2 and 3, which is being dealt by the trial court. It's a very long order, my lord.
Now, what you have recounted is only what the trial court has
recorded the submission of the prosecution and accused number 2 and 3 now, right now. Then accused number 4 and 5, then the findings come. Should I take a lot of
relevant portion of
Findings.
Findings are at paragraph 95 onwards, my lord. Prior to that, only the submissions have been recorded. Para 95 onwards, the findings of the trial court.
Page 202. I'll read para 95 onwards.
Yes.
On perusal of the written argument by the CBI shows that it is totally silent on the issue of the charge sheet having been filed on the basis of invalid documents, that is, the earlier audit statements of accounts and utilization certificate which have been withdrawn and as such cannot be relied upon in any manner. In the documents which has been produced by the accused persons and could not give any clarification as to why these documents have been suppressed and ignored in the charge sheet. The prosecution has a higher duty and responsibility to prove its case, but when there is doubt in the prosecution story and benefits goes to the accused, it is so is this case, since it is on record that many relevant documents have been suppressed and charge sheet has been filed on incomplete documents. Prosecution against the other accused person, number 1 Sri UN Maji, number 2 so and so, number 3 so and so, also is not sustainable, as it is apparent on record that charge sheet has been filed on the basis of invalid documents, incomplete documents and suppression of other relevant documents. Annexure 2 page 25 shows sanction was with approval of secretary. There is no complaint or objection from secretary NEC about no approval taken from him. On the contrary, secretary congratulated the good work done under the scheme as apparent by annexure so and so, has clearly confirmed their acceptance on principle to the expenditure of rupees so and so incurred under the scheme pending up to date audit report, and also observe that the implementing agency has spent more than what has been released to the NEC so far. The college on 22/7/10 submitted to NEC the consolidated audited accounts for the period 22/3/2005 to 31/3/2009 along with remaining vouchers. Thereafter, college submitted the consolidated utilization certificate dated 29/9/2009 for the period so and so so and so. As such, it is clear that the sanctioned funds of NEC has been properly and fully utilized. Therefore, it is futile to proceed with the prosecution against the accused. The funds as alleged. Moreover, in view of the Honorable High Court judgment and order dated 31/12/2013 passed in criminal miscase number so and so, the charges framed against the accused person is number 1 so has become defunct. As relied upon by the my lord.
What is this order pass?
The High Court order
31/12.
But this is the order by which additional documents were allowed to be produced, my lord.
No, my lord.
No.
By this order, the other accused number 1, 2, and 3, against whom charges were already framed, and it was allowed that their case to also be again considered. They should get the benefit of that other order which was passed, where the Honorable High Court directed the trial court to take into account, to consider the documents at the time of framing of charges. And they were also given the same benefits. In a way, the charges which were framed against them were already set aside by the High Court. And CBI never challenged that order when this benefit was given to accused number 1, 2, and 3 for reconsideration by the trial court in the case of 4 and 5, against whom charges were not framed. But at that stage, CBI never challenged this order.
31/12.
Okay. So the charges framed against them has become defunct in the sense that it has
in
to
view
be,
of that order.
It has to be reconsidered or otherwise.
Together with 4 and 5, which should be considered at that time. So they got the benefits. That was never challenged by CBI earlier. My lord, the entire findings of the trial court starts from paragraph 18 96 is the final decisions from 96, but the observations of the trial court, where trial court gone into considered all the documents, which are the documents considered by the trial court, which are documents were looked into by the trial court. Everything starts from paragraph 80. Paragraph 80 onwards, and from 96 it is the findings. Para 80 is at page 188, my lord.
So, Dr. Musika, seems you are not prepared.
But I thought I'll take a lordship to the entire order. I can refer to from para 80 also. I'll read from para 80. Well, basically here what happened, my lord, after filing of the charge sheet, after CBI filed the charge sheet, there was subsequent development, my lord. Somehow they withdrew the utilization certificate that was earlier given, my lord, by them. And they received some letter from NEC. Then they came to before this honorable court, my lord, to allow them to produce the defense documents at the time of charge sheet, my lord. Now our case was that when we filed the charge sheet, those were subsequent developments. Those were not available with CBI. The findings of the trial court, my lord, that CBI is annexed incomplete document, incomplete investigation. The wordings used against CBI, my lord, in the imbued notable lordship has seen those. Now, after filing of the charge sheet, charges were framed against some of the accused, my lord. Then they came before this honorable court, and the lordship will kindly see the date of filing of charge sheet and the subsequent development, my lord.
If I may submit, my lord, just to clear the things, I think my learned friend is not very clear with the facts. Here it is not subsequent development, my lord. Even the charge sheet which was filed by CBI, that was based on invalid documents. Why? Because on the date of filing of CBI in their affidavit clearly admits that they have based the charge sheet on the basis of 3 utilization certificates. Entire charge sheet is based on 3 utilization certificates. But CBI did not take into consideration the fact that those 3 utilization certificates were withdrawn. Once the certificates were withdrawn, and those are invalid documents, they were not relied upon. It was withdrawn with the permission that we should be allowed to file a consolidated audited account statement and audited statement. So once a document which is withdrawn, it becomes inoperative. One cannot rely on those documents. They are non-existent documents, invalid documents. It cannot be operated, it cannot be acted upon in any manner. So irrespective of the facts that utilization certificate, which my learned friend is telling, that these documents are subsequent development, even without that also, the charge sheet cannot stand, because the charge sheet is based on documents which stands withdrawn. So that point my learned friend is missing here. And instead of going into the entire thing, your lordship, if we just come to the grounds on which this instance civil revision is filed, what is the ground they are challenging? On what ground they are challenging? Most of the grounds which they are challenging, that already stands finalized. It stands closed by the Honorable High Court's previous order, which they never challenged. Again, they are repeating the same thing, that at this stage, the Honorable Trial Court could not have looked into those documents. That cannot be reopened in this case. On what ground they are challenging that order?
Anyway,
that has to be seen.
Anyway, what if I understand correctly, what Dr. Musika is trying to do is trying to place the case, going into the history of the matter.
Yes.
So as far as those subsequent development, this and that will come later. Whether they were correct or not, whether the veracity of your statement is correct or not, that will come later. But what you are trying to is saying that.
What I am basically trying to say, my lord, the charge sheet was filed on 30 July.
CBI has filed charge sheet. We start from there.
But charge sheet was filed on 30/7/2010, my lord. July 2010 was the charge sheet, my lord. And the documents which they produced, my lord.
Charge sheet filed on
30/7/2010.
2010. Yes.
Now, my lord.
Any consideration of charges or argument before charges was?
Now, my lord, after filing of the charge sheet, my lord, charges were framed against on 19/12/2011, my lord. Can I just give few dates, important dates?
Charges framed?
My lord, charge
Against
sheet
1, 2 and 3.
on 19/12/11, my lord. 19/12/2011.
Against 1, 2 and 3?
Against 1, 2 and 3.
On
19 December 2011.
2011.
Now, my lord, after filing of the charge sheet, now trial court has relied on documents. I'll just give you some of the dates, my lord. One is letter dated 2011/2010. This is subsequent to filing of charge sheet, my lord. 13/12/2013, my lord. Then June 13, my lord. The subsequent developments.
So these were not part of the charge.
These were not for part of the. These were not available at that point of time, my lord. So the finding that there was suppression of fact or we produced incomplete document by the trial court. Well, trial court at the most could have said, well, these documents were not available at that point of time. Now these documents are available. So that is our case, my lord.
My lord, we have to pause here 1 minute. My learned friend had said charge sheet was filed on 30th July 2010. So we take a pause here. Charge sheet is filed. On what basis charge sheet is was filed? Charge sheet is based on what? We have to look into that. Charge sheet, they have, in their affidavit, they have clearly mentioned in their affidavit before this honorable court, which affidavit they filed in the earlier criminal revision. They have clearly mentioned 1, 2, and 3. These 3 utilization certificates, they base the charge sheet on these 3 utilization certificates. But on the date of filing of that charge sheet, these utilization certificates were already stands withdrawn. Forget about subsequent development, other dates, documents which were filed later on after the charge sheet. Whether CBI could have filed the charge sheet on the base of these documents, the whole case is that. Our entire case was that. Forget about the subsequent. The subsequent one was the.
So
yes,
so the trial court has taken cognizance of that fact.
Yes, once a document which I withdrawn, which is no longer in existence.
So
we filed the utilization certificate.
My lord, once CBI investigation is started, can they withdraw the documents like that, my lord? My lord, what they do, my lord, once they are caught, once they are caught, my lord.
My learned friend is missing the point, my lord. Those certificates were withdrawn even before the CBI inquiry was initiated. What has happened, my lord, in this whole case, why the utilization certificates had to be withdrawn? Because as per the project proposal that we submitted, we clearly mentioned spatial requirement is one of the components. And so with the belief that acquiring of land is within, as per our thing, it was within the one of the component of the project proposal, we purchased land with the money which was sanctioned by NEC. But subsequently, NEC said land cannot be taken by this money. Land is not a part of it. We did not want to go into controversy with NEC. Then we said, if land is not, then land is our contribution. So whatever we spend for the land, that will be from the college side. But then that money we have to show, it is only the accounting part, Your Lordship. So that money which we have purchased by land, so land component we paid from our side, from college side, and that money which was spent for the land, we utilized for the other one. So that needed a change in the account statement of accounts. So NEC told us, then you withdraw this earlier statement of accounts and fresh statement of accounts showing the details of statement of accounts only for the components which were allowed under the project should be shown. And that's why we withdrew all the 3 previous utilization certificates and audited statements. And a fresh consolidated statement of accounts and audited statement was submitted to NEC.
See, but that was the whole episode took place in course of investigation. Because charge sheet has not yet been filed.
Took place later. No, charge sheet was not filed.
Exactly. So it was still in course of investigation. what prevented you from informing the IO that this
And
these
that
are
is what
the
is the case, my lord. Yes, everything was there. Even that document by which it shows that we withdrew we have withdrawn the utilization certificate. CBI seized those documents, but CBI never relied on those documents, forwarded those documents before the trial court. That is why the earlier episode is there, my lord. We filed a petition under Section 91, requesting the court to direct CBI to produce all these documents which they have seized. They picked and choose manner. They did not take note of those documents. They did not produce. And there was a clear order and direction by the trial court. Even then, CBI did not produce these documents. That is our case.
I'll hear
That's why we had to come.
I'll hear your part. I'll hear your part of the argument on that matter. Let's
Yes,
see what the CBI say. See, Dr. Muzika, at this point of time, whether it's required to go into all those, to produce whatever documents that is in your possession or that was taken into account by you when the charge sheet was filed. If you see, if I understand correctly, what has been submitted is that there are some documents, particularly with regard to the withdrawal of those UC, which were already, made known to you during the process of investigation, but which were not taken into account by you. I'm not saying concealed, not taken into account by you when the final report was filed. So now, how did that happen? Whether you had, you were in receipt of those UC or withdrawal of those UC, communication to that effect, is it there in your record? Because what you would find, what you would have with you is those UC. You would have with you those UC.
Withdrawn UC.
Not the withdrawn, the UC before they withdrawn. You would have those. So you would rely on those. Subsequently, in course of investigation, those UCs were withdrawn by the authorities, whatever. So that's what they said. That's what they said. That's what they said. So that communication, as has been, if I can understand correctly, was made known to you. But in the final analysis, you have chosen not to, depend on those, on that withdrawal.
But we have to correlate. We have to correlate the dates.
There's just there is just one point, if I may clarify. We withdrew the UC even before filing of FIR.
Exactly.
6th May 09, we withdrew all the UCs. Okay. And FIR is filed on 8th May 09. All these documents were seized by CBI. But they picked and choose manner, they did not take in note of that. All these three UC, basing on which they filed a charge sheet, it stands withdrawn, and those are invalid documents.
That is the clarification that is sought for by the court.
Yes.
During the preliminary inquiry, when
the
CBI started preliminary inquiry,
just a minute. I've understood your case.
When the CBI started preliminary inquiry, my lord, when they thought they will be caught now, that are trying to
we withdraw as per the direction of the NEC. There's nothing to be caught at that point of time.
Now, what has been submitted is that even before filing of the FIR,
but a preliminary inquiry was going on. So CBI was already in control of the things, my lord. So when they sensed that this was going to some problem, my lord.
So even so, even during
even if how can CBI
just
without an FIR?
Please. Even before, you see, in the course of preliminary inquiry, if these facts are known to you, the withdrawal of the UC, that should have been taken into account by you when the FIR was finally filed.
I'll correlate the dates, my lord.
Because that would be
how many of the documents, my lord, which the trial court has relied on, are subsequent to the filing of charge sheet, my lord?
You have to satisfy this court that when the preliminary inquiry was going on, before the registration of the regular case, that is filing of the FIR, was this thing known to you? And what was did you ignore it or did you find it not relevant?
Number one, whether those were available, and number two, whether we ignored that or we didn't take that.
Exactly. I think that would require a chart. Then.
I'll make a chart, my lord.
My lord,
sometime.
this is as registered as a criminal revision petition, my lord. And now, to my understanding, my lord, a criminal revision petition has a very narrow scope. And it's only illegality of the order or jurisdictional error, which so far the CBI has not been able to give a little hint of it also, my lord.
Anyway,
that's in the merit of the case.
Let us understand the genesis of the matter. How it transfers. It's like a story.
My lord.
First you read chapter 1. Now we are going to chapter 100. So now I'm confused.
This is actually, my lord, as admitted by the learned senior, my lord. It says that how can such a word like suppression of materials can be used by the trial court while discharging this order, my lord, by discharging us, my lord. It seems that, my lord, they don't have any case. They are here before just a certificate. They have satisfied their ego to say the least, my lord. It appears like that, my lord, because they are saying that how can the learned court use this?
The word suppression used would be in the context of what Madam has submitted.
My lord.
As far as those withdrawal of those UCs are concerned. Yes. If it is in their knowledge before the FIR was filed or the regular case was registered, and they choose to suppress that.
Yes.
But if they see that they have no knowledge of such an event, then
and some
only
of the documents
records will show.
And some of the documents are subsequent to even filing of charge sheet. That cannot be suppression.
Yes, that of course.
No.
Then we'll have to look into that aspect.
I'll make a chart, my lord. I'll place.
You can do also this.
My lord, even in spite of the clear direction of the Honorable Trial Court to produce those documents, when we gave the list of documents and filed a petition under Section 91, after that also it is matter of record. It is recorded. They did not produce all those documents.
The list of documents.
They did not file.
See, the list of documents that you have produced, were those documents in their possession or they were with you?
Everything was seized by CBI. Everything is under their possession. Each and every document pertaining to this project was seized by the CBI.
I understand.
But in spite of direction from the court also, they did not produce those documents. So isn't it an act of suppression?
With the project money, they buy land, my lord. Oh, 2 crore.
Land we have paid from our pockets. Land we have paid. And in
only
fact,
only after they were caught, my lord.
My lord, in this case, there was a stage when we
it is like
wanted to return.
After being caught, my lord, the thief says, okay, you take back and exonerate me. That doesn't happen, my lord.
No, my lord.
Sometimes people are satisfied with that. Instead of going to the hassle of...
At one point of time,
but the complainant may not do, my lord, but the state has to take care of that.
Please do that.
I will do that.
1 week.
I'm praying for it. Next week I am not here, my lord. I have to go to...
2017 matter. You see, cannot...
I understand, my lord. It appears Mr. Jindal earlier argued many times, my lord.
Let's say, only saving grace here, if we put it that way, is that the respondents are out. They are now, you see.
No, but out, your lordship. But
physically,
hanging, my lord.
Oh, that's
physically. Sword is always hanging.
That is
sword
true.
Yes, my lord. My lord, one of the officer, his pension has been stopped, my lord. He's not getting. I think Sir Siddiqui's Sir Qureshi's client.
For that he has to file a writ petition, my lord. In this matter, I don't think lordship passing out on that.
And there is no stay. Interestingly, my lord, there is no stay. My lord has not granted stay. In spite of that, it's not this thing.
No, CBI is not stopped. CBI is not nor directed initiative not to release pension. But
whatever the case may be, see, since the impute order has discharged him.
Yes.
By the impute order, they were discharged. Nobody is, the case has practically become.
Yes, as on today, there's no case.
There's no case.
Yes.
So the file is just
no, my lord. Even
except
government of as per.
Except for the consequent, the subsequent event, like not non-payment of a pension. I think he has given you a hint there.
So then we have to challenge before the cat only.
Then you do that.
Funding authorities is
If there is no
satisfied.
stay in the
Government of
if there's no stay in the criminal proceedings,
No, my lord, I don't understand. My lord, one here your lord has to see. I don't know what role CBI is playing. CBI is only a fact-finding authority. They have to play a very unbiased role.
Yes.
Here, the funding agency themselves are satisfied with the utilization. Government of India themselves has said projects which are more than 10 years old.
It's not that
No.
simple. It's
My
not
lord,
that simple.
Government of India themselves has issued a notification that projects which are more than 10 years old should be closed for all practical purpose. We have also filed it before the Honorable Court. And on that basis, the college was asked to close this project. In spite of that, CBI, I don't know what vested interest they have. They are hell-bound to
we are not here. We are not here on the issue of when the project has started and when it was closed. We are here on how the project was actually processed. We are here on that. Whether it was done rightfully or wrongfully.
My lord, if that be the issue, then that give us more handle to go out, because the Supreme Court says that mere irregularity in the procedure, that's not a criminal offense at all. If that be the issue, we are already out, my lord.
I understand you are out only.
Dr. N. Musical at DSGI has advanced argument in this case to a certain extent. However, in the midst of the hearing on a query made by this court, the learned DSGI has submitted that he may be allowed to assist the court by filing the relevant list of dates, etc., to be brought by way of a chart. Pre-allowed. The respondents are also at liberty to do the same in assistance of their cause. If you want to file a chart, you can also do. If we see,
I've already submitted my written submission.
Fine. You are already sure of your case, so yeah. On pre-made, this is matter after 2 weeks. 2 weeks.
2 weeks. 2 weeks.
But the next week I have to go for my daughter's 3 weeks, my lord. The preparation chart also takes some time.
Today we are on
30th of May. 3rd week of June, my lord.
6. I think we have to fix a date for this case. We cannot just.
Yes.
You suggest a date then.
20th of June, my lord.
June.
This side.
No.
Thursday.
20th.
20th.
My lord, 30th of June, my lord.
30th will be too long.
30th is Sunday also.
That's a Sunday.
Oh.
30th is Sunday.
On Monday?
24th then.
Monday?
Monday after that or
No, my
before
lord,
that?
I'll have it.
Asking 1st of July, I think.
My lord, but 1st of July, my lord?
No, 1st of July will be too. We are not only in June.
1st of July?
May, man.
When will you be available?
On the 1st of July. Either we can do it on 3rd, 4th June. I'll be available.
The 3rd, 4th,
Or on
I
1st.
have to travel.
So if your lordship is okay, if your lordship
no
is, because my lord, I would like to argue it physically. So June it will be a little difficult.
So 1st July.
1st of July, yes, my lord. Obliged, madam.
But
Obliged.
we will do one thing. 1st of July.
Yes, madam.
If
Yes,
we'll
madam.
see how the we'll see the manner of the board.
Yes.
But if required,
Yes.
we can have this matter in the second half.
Yes.
But we will do it.
Yes,
We'll
madam.
On that day,
we'll conclude that.
by any way.
We'll conclude it.
So whatever you have in mind, whatever you feel would be
Yes,
of
madam.
assistance to court, do that in a way of filing of chart, filing of synopsis and whatever. We'll do it.
We'll conclude it. We'll try to conclude on that day itself.
Please.
Obliged.
Obliged, Your Lordship.